Hello and welcome to Bold Radio. I'm your host, John McLeese. Sometimes in life, you just need some good advice. No one is an expert at absolutely everything. That's why we're proud to present the Bold Radio Expert Series, where we welcome a qualified and experienced individual to offer sound advice on an aspect of running a business. Our guest today is a highly qualified human resource expert. We're pleased to be joined by Jamie Jurczak, who is representing the Human Resource Management Association of Manitoba. Jamie is a partner at Taylor-McCaffrey LLP and will be bringing her expertise today to the subject of duty to accommodate. What do we mean by that? Well, not everyone's abilities or circumstances are equal, but it's important that an employer try to provide everyone with an equal opportunity to succeed. This isn't always an easy or straightforward task. In some cases, it may require some accommodation. Jamie, welcome to the program.
Thank you very much, John.
It's great to have you. How would you define an employer's duty to accommodate?
Yes, how would you define that? And I think it's certainly one of those things that it is very difficult to define, which I think is sometimes why employers may have difficulty meeting their duty to accommodate. It can mean many things depending on what right or characteristic needs accommodation. So I think that's an important place to start, is to recognize this comes out of the human rights legislation, the Human Rights Code, or if you're a federally regulated employer, the Canadian Human Rights Act. And both pieces of legislation, and indeed all human rights codes across Canada, recognize certain protected characteristics, gender, disability, religion, just to name a very small few, recognizing that these characteristics may have led in certain circumstances to people either being discriminated against or disadvantaged, and that in order to allow for full participation in certain aspects of society, such as a workplace, and to prevent discrimination, particular special needs that arise out of those characteristics may need accommodation, meaning some particular special or differential treatment to provide for that person's full participation or to prevent discrimination.
Now, I think a lot of our listeners who may be familiar with this topic would certainly understand about the accommodation for disabilities, but disabilities is just only one of the areas, as you mentioned. Expand on some of the other areas that are part of this legislation.
Absolutely. So physical or psychological disabilities are only, again, one small piece. Age, gender, race, religion, family status, more recently, socioeconomic status has been recognized under human rights legislation as different, again, protected grounds in need of potentially accommodation in certain circumstances.
What is an employer expected to do if an employee approaches them requesting an accommodation?
Okay, so when that happens, an employee will, again, typically approach an employer and say, I have this particular protected ground, and therefore I'm going to need some assistance because it requires accommodation. So I have a particular religious affiliation that means I can't work on a particular day of the week. I have a family situation that's going to require some accommodation on the basis of family status. I have a physical disability that's going to require maybe a physical aid in the workplace, or it's going to limit somebody's hours of work that they can work for an employer, or maybe requires a change in duties to accommodate that physical disability. When an employee approaches the employer, there's no particular process per se, other than the importance of them engaging in the process. So the employer needs to take some opportunity to sit down, analyze the situation, try and understand what the employee's needs are and the nature of the accommodation they're requesting, and then undergo a very thorough analysis of their workplace, the duties that the employee can or can't perform, what the restrictions may be, what they can do, and see if there's a way that they can restructure things perhaps, reassign some things perhaps, in order to accommodate that particular need. And if they're ever called to task on that, if somebody ever challenges whether or not there was an accommodation, they will be expected to show that they engaged in that process, analyzing the workplace, including the employee in those discussions, asking them questions. If it's a unionized environment, engaging the union, perhaps other experts if they need to understand maybe physical accommodations or some health issues that they need to address.
Well, let's look at it now from an employee's perspective. If an employee requests a specific accommodation, does the employee have any obligations?
Yes, they absolutely do. In seeking the accommodation, it's completely reasonable, and in fact, human rights commissions and courts have confirmed that it's appropriate that the employer can ask for certain information of the employee to make sure the search for accommodation is meaningful. So I'll give a very common example is an employee with perhaps a physical disability may approach the employer asking for an accommodation. The employer needs to be able to understand what perhaps their medical restrictions may be, what their physical capabilities are to ensure that they're providing the appropriate accommodation. If suddenly the employee says, well, that's private, I don't have to tell you, I'm just going to tell you that I need this physical accommodation and that's that. There might be a circumstance where the employer has actually met their duty to accommodate. If they say, well, then we can't help you. It's appropriate to ask for questions in that circumstance. And in fact, the employee has a duty to participate in that search.
So there's some obligations from an employee's perspective as well as an employer. Our final question, Jamie, and we're talking about the notion of duty to accommodate and the whole notion of legislation around human rights. Undue hardship. We've heard that term before. I've heard that term in the workplace before. What is undue hardship and what factors are considered in determining whether there is an undue hardship created by the requested accommodation of an employee? That's
an excellent question. Now, undue hardship effectively is the limit that's placed on an accommodation. So we often hear the phrase, there's a duty to accommodate to the point of undue hardship. So when an employee comes in and says, I'm requesting accommodation, and they may have a plan or an idea of what that could look like. That may be something that's feasible for the employer. It may not. So when somebody is considering all the factors that, can we do this? Can we put this in place? Can we meet this particular need? If it places an undue burden or an unreasonable burden on the employer that is undue, and of course, what that means in any particular circumstance is, of course, going to depend on the nature of the accommodation requested, the size of the employer, the costs that may be involved, other workers that may have to be displaced and the like. But when you can demonstrate that it's undue, then the accommodation won't be required. So effectively, it excuses somebody from having to meet that duty to accommodate. And I did mention a few of the things that commissions will look at: cost, perhaps safety risks, displacement of other employees, the size of the workforce, whether there's interchangeability of workers to allow for that accommodation and the like. But I think it's important to recognize that it's undue hardship, which in and of itself describes that there is expected to be some hardship that might come out of the accommodation. So it does need to be undue.
Duty to accommodate in Canada. This is the law according to human rights legislation. Jamie Jurczak is the Human Resource Management Association of Manitoba's expert and a partner at Taylor-McCaffrey LLP. Jamie, thanks for joining us.
Thank you very much.